Hello everyone, my name is Deepashree. I would like to welcome you all on video presentation of Repealing of Outdated Laws. What are laws basically? Laws are binding rules and regulations, customs and standards established in the community. So whenever the community changes, the law also should be changed either by amendment or repealed to make it suitable to the dynamics of the community. So the law becomes obsolete when they hold no relevance to the current functioning of the society and fails to regulate the society anymore in its changed dynamics. The laws that become obsolete needs to be repealed for the betterment of the nation. Repealing means to abrogate, revoke or cancel a particular statute. So abrogate means to put an end to, revoke means to cancel or invalidate by withdrawing or reversing. Cancel is to invalidate. So all of these are synonyms, which means to nullify the existing statute. Any statute may repeal any act in whole or in part, either expressly or impliedly, by enacting matter contrary to or inconsistent with the prior legislation. So let us break down the sentence and try to understand it in parts. So any statute may repeal any act in whole or in part means a statute may be repealed completely. That means it can be completely removed or it can be repealed in part, like the part of the statute may be removed or replaced by new statute. So either expressly or impliedly. What does this mean? So express repeal occurs when express words are used in the statute to repeal an earlier statute. They are now included in the table in a schedule to the statute for the reason of convenience, so that the user of the statute may easily know what has been repealed. When statutes are repealed, the text is simply deleted from the code and replaced by a note summarizing what used to be there earlier. Example for this is Section 23 of Hindu Succession Act 1956, where the section is omitted completely currently. An implied repeal occurs when two statutes are mutually inconsistent. The effect is that the later statute repeals the earlier statute. Moving on, under common law of England and Wales, repealing a law means to obliterate it completely from the records of Parliament as though it had never been passed. It will be assumed that the statute was never existed. So two types of repeal under this is repeal with reenactment and repeal without replacement. Let us try to know what it is. Repeal with reenactment is where the law in the area is being updated by the law being repealed needs to be replaced with one suitable for the modern era. So the reenactment can be done with or without amendment. It usually gets done with amendment. If it is done without amendment, it means only in the context of consolidation bill. So that means a new bill will be passed with it if it has to be done without amendment. So example of such repeal with reenactment is the Poor Laws in England in 1948 was replaced by modern social welfare legislation. Since the Poor Laws was no longer relevant to the England's dynamics, so it was replaced by modern social welfare legislation. Repeal without replacement. So repeal without replacement means it will be removed completely, making it nullified. So a repeal without replacement is generally done when a law is no longer effective or it is shown that a law is having far more negative consequences than were originally envisioned. A statute, when enforced, may have its objectives set for the relevant to that days or the current society's objectives. But later, when these dynamics of the society changes, the slave law may bring in negative consequences. So there is a need for replacing it or removing it. So example of such a law would be laws on license to kill and capture of wild elephants in certain circumstances in India was repealed in 2015. Perpetual or temporary statute. Statute is either perpetual or temporary. It is perpetual when there is no time is fixed for its duration, and such a statute remains in force until its repeal, which may be express or implied. So, whenever a statute has its validity fixed at the beginning before the enforcement of the statute, then it is called temporary. Otherwise, it will be perpetual. But a perpetual statute does not mean that it cannot be repealed. It is perpetual in the sense that it is not abrogated by efflicts of time or by non-user. So it remains to be there until there is a need arises to repeal it or to replace it. Until that time, it will continue to exist. A statute is temporary when its duration is only for a specified time, and such a statute expires on the expiry of the specified time unless it is repealed earlier. So, at the beginning of the enforcement of the statute itself, the time duration will be fixed, be it for like 5 years or 10 years, or particular year will be mentioned, and that statute will remain in its force only during till that time. On arrival of that time, the statute loses its validity and it will no longer be effective. So, but it can either be extended or it can be repealed earlier than the validity. So, example of such statute would be Citizenship and Entry into Israel Law, enacted in Israel in 2003. The law had its initial validity till 2007 and later it was extended. So, if the need be to extend the law to govern it for a little more time, then it can also be extended. Coming to the context of India, we have something called as Ramanujam Committee. So to understand what this committee is, as early as in 1998, the Atal Bihari Vajpayee government back then had appointed a committee on the review of administrative laws. But the committee recommended repealing 1382 acts, but only 415 have been repealed so far. And recently, during the governance of Narendra Modi ji, on 27th August 2014, a Ramanujam committee was established to identify obsolete laws. The objectives of the committees were to identify the laws that they have believed hamper the governance by creating confusion, like if their terms or if their sentences or does not bring in any meaning to the current situation of the community or the society, then it would be confusion and it would hamper the governance because the government or the legislation would not know how to enforce the law in the current situation of the society. The committee will submit the report in 3 months, and based on its recommendation, a bill will be introduced in Parliament in the winter session. So it is important to know that even for repealing or amending any law, a bill should be passed, and that should also go under the legislation for its approval. So the third objective was that the committee will examine acts and rules that may have become obsolete within 10 to 15 years. And meanwhile, the Law Commission of India also reported its 248th interim report on obsolete laws. A study was undertaken called the Legal Enactment, Specification and Streamlining. The committee on 12 September 2015 submitted 4 interims report titled Obsolete Laws Warranting Immediate Repeal. It had identified, analyzed, and duly recommended a number of archaic statutes as well as certain pre-constitutional, pre-independence enactments for either complete or partial repeal as per contemporary requirements. So you can imagine how archaic it can be, because if it is enforced pre-constitution and pre-independence, it is almost 73 years now that India achieved independence. So most of the laws would have no significance or no relevance, or would mean nothing for the current society. The 248th report recommended the repeal of 72 statutes and identified another 261 for further scrutiny. And the 249, 250th and 251st interim reports by Law Commission of India on obsolete laws. It was on October 2014. The 249th report was submitted. It identified 74 more statutes. And there were separate recommendations on partial repeal and on 11th World War II ordinances. And in the same month, 250th report was also published, and it identified 73 more statutes. And in November 2015, in the 251st report, 30 more statutes were identified. So it total summed up to 288. So these are some statistics related to repealing of laws in India. So since 1834, 6,612 central statutes have been enacted. And at some point or the other, 3,831 have been repealed. And the existing ones are 2,781 from 1834, this is. And then again, 1,741 central acts were identified for repeal, out of which 777 needed to be repealed by union government, 83 by state legislatures, 624 by central appropriate actions, and 254 by central appropriate actions on state subjects. So what has been done so far is 125 statutes have already been repealed, 35 by Repealing and Amending Act 2015, and 90 by the second amendment of Repealing and Amending Act 2015. So by this it is clear that we have not even done 10% yet. What is Repealing and Amending Amendment Act? It is a bill that was introduced in 2019 by Lok Sabha by the Minister of Law and Justice, Mr. Ravi Shankar Prasad. The bill seeks to repeal 68 acts and also made minor amendments to 2 other laws. The Repealing and Amending Bill 2019 repeals 68 laws that have been listed in its first schedule and bill in all. So these were the objectives and these were the accomplishments of Repealing and Amendment Act. So let's look at few of the completely obsolete laws that are still existing in our books, and they're still active, but though they have not been enacted or they hold no significance, they're still there. So let's have a look at those. The first one being Indian Police Act 1861. So you can know this is also from pre-independence colonial period, enacted by the British legislation. The British, after the revolt in 1857, to bring in effective administration of police in the country to prevent further revolts, enforced this act. So the British seem to be threatened by the revolts made by Indians in order to free themselves from the slavery of British. So in order to protect themselves, this act was enforced by the British. So under this act, all the powers were concentrated in the hands of the state, which used to act as a dictatorship government. So we all know it's been 73 years that India achieved independence, and now we are called the sovereign state where there is no concentration of power. In a country of sovereign nature, the existence of this act is of no relevance. And also the states of Maharashtra, Gujarat, Kerala and Delhi have passed their own legislations in this regard, but these laws appears to be derived from the same Indian Policy Act of 1861. So it would have the same essence of Indian Police Act 1861. And this act has continued despite India being transferred from British colony to Sovereign Republic. So you can imagine what an archaic act it is. Sedition Law, Section 124A of IPC. So this was also during the colonial period and enforced by the British. So it was first introduced in 1835 and was legally made into a criminal offense in 1870. It was started in England under the Treason Act 1795 during the lifetime of King Charles II. It was under his rule, it was considered an offense to raise their voice against the king. So it was more of an monarch type of rule where the orders of kings were final and no voice against that or any suggestions or feedbacks regarding the king's rules or king's governance were discouraged. So, like in the context as such, this law was made, and in India, its relevance holds when few Brahmins were inspired by the speech of Bal Gangadhar Tilak, and they murdered two British soldiers in Pune. So the British, in order to convict Bal Gangadhar Tilak, enforced this act, this law called sedition law. So then the senior Congress leader Seth Govind Das spoke in the House on December 2, 1948, that is after India achieving independence, and said that this section was made for securing the conviction of Lokmanya Bal Gangadhar Tilak, and the word sedition was removed constitutionally. Though this was removed constitutionally, it still remains in our IPC under section 124A. Dramatic Performance Act 1876, again enforced by British legislation during the colonial period. The British, having been threatened by the performances and the dramatic public performances that excited the feelings of Indians, in order to fight against the British, having threatened by such act, launched this, which prohibited the dramatic performances of scandalous and defamatory nature. But following India's independence in 1947, the act had not been repealed because it is very clear why it was done and what was its actions and by whom it was done. And so there was a need for repealing it post independence because the British had left us by then. But it is sad that it's still not been repealed, and most states have introduced their own modified versions with certain amendments, except the state of Delhi and West Bengal. And also, the Law Commission, in its 248th report published in 2014, recommended the repeal of the Act. So, this we discussed earlier that the Law Commission, in its 248th report, had identified few laws for repealing, and this was one such act. But unfortunately, it has not been repealed yet. The Law Commission said that it was enacted during the colonial era and extensively used to curb nationalist sentiments propagated through dramatic performances. It has no place in a modern democratic society. We know that India is a democratic country where people have equal say in the functioning of the government. So there is no need to prohibit any act or any thing as such, because it is again against our constitutional values and our fundamental rights. In 2014, also the Madras High Court held that the Tamil Nadu Dramatic Performance Act 1954 should be repealed as its violation of Article 14 and 19 of the Indian Constitution, which is of equal protection of law and equality before law. So this is against our fundamental rights. Indian Treasure Trove Act 1878. enacted by British again. So this is by far the most bizarre act because it says anything of any value hidden in the soil and worth as little as 10 rupees would be considered as treasure. And the finder of such treasure, according to law, should inform to the most senior local official and the nature and the amount or approximate value of such treasure and the place where it was found. And if the person fails to hand over the booty to the government, the share of such treasure shall vest in her majesty. So that is referring to Queen of the United Kingdom. Again, very evident that it's been 73 years British left us, and there is no queen or king in our current democratic country. So this act has no governance or brings no meaning, and it needs to be scraped out. Indian Post Office Act 1898. The British during their rule retained the privilege of conveying the letters within themselves, that is within the government. Uh, Under section 4(1)(a) of Indian Post Office Act, it says that letters sent by private friend in his way, journey or travel to be delivered by him to the person to whom they are directed without higher reward or other post or profit or advantages for receiving, carrying or delivering them, which means it has to be done at free of cost. Post independence, when the Indian courier industry and all started booming, this was seen as an hindrance for their profit because Indian courier industry was expected to send letters at free of cost according to the provision of this act. So, in order to bypass this section, the Indian Courier Service have been sending even the letters as documents to make it costly or to price the delivery of the documents. Salts Act 1953. It was ascended by the Honorable President of India on 26 December 1953. This is post-independence, an object of imposing and collecting the Sazon salt for raising funds for the purpose of meeting the expenses, that is the administrative expenses in manufacturing, supplying and distribution of the salt. And this was for the organizations maintained by the salt organizations maintained by the government. Uh, but the imposed rate was 14 naya paisa per 40 kgs. So this is the tax imposed on private or state-owned salt factories. So it was observed later that these tax amounted just for half of the cost of collecting the tax. So the cost of collecting the tax itself was so high that the income arising out of the tax was so less, it was not even considering off of the cost. So it was very clear that government was incurring loss. But in spite of all these losses and the irrelevance of this act, it continues to be in existence. So also, the High Level Salt Inquiry Committee was set up in 1978, recommended that these tax should be scraped out. And although 92% of salt in India is produced by private companies, its salt industry is controlled by Indian Salt Service Act. So this by far brings no revenue to the government, and its existence is of no use, and it needs to be scraped out. That is what was recommended by the Salt Inquiry Committee as well, but it continues to be in existence. And while discussing this act, it is also important to remember the Salt Satyagraha movement in India, which was led by Mahatma Gandhi ji. This moment was fighting against the Salt Tax Act, which was enacted in 1882. This act accounted for 8.2% of British Raj revenue from the tax. So that act, which was enforced in 1882, was still beneficial to the government by bringing 8.2% of revenue. But this act, which is existence and which was enforced in 1953, needs a strict review, as it is forget bringing revenue to the government. It is actually a cost to the government. Moving on, let's try to know what are the challenges on repealment of these acts and why are they still in the books in spite of having been identified that they hold no relevance and they needs to be repealed. They are still in existence. So what might be the challenges that the government or the legislation faces in repealment of these acts or laws? So there are cases where a statute needs to be retained but has sections that should be scraped out. So a statute in its whole might still be relevant to the society and would be capable of governing the society, but the part of it may be irrelevant and needs to be scraped out. So that brings in a challenge to identify, to modify the statutes to retain its relevance and to only remove the sections which are not relevant. And there can be instances where consolidation and harmonization exercise is required. So as we know, India is a democratic country and people have say in the formation and laws, the legislation, everything. So sometimes what happens while bringing in the new statute or removing the old statute or fixing it by amendment, we need to consider the people say as well. So if there is no unanimous opinion about the repellment, then it would become chaotic. So the government may let it be, let the statutes or the acts be in the way they are currently. And there are also instances where repeal has to be matched with new legislation to plug in the gaps. Obviously, it cannot be done outrightly without much preparation and planning. There should be plan B or the alternate law identified to fix in the gap when the old law has been removed. So if the old law, if the government feels that the old law is failing to govern the country in its change dynamics, then obviously it has to bring in new legislation to make it effect to the current functioning. So in if first the step is identifying the outdated laws and to identify the alternate laws to fix in the old laws. So this becomes a time bound activity and it has cost involved in that. So it cannot be done outrightly. All this brings in challenges for the government as well. But surely these archaic laws are burden to the legislation and they need to be scraped out. And though many attempts have been made till now by the government to scrape it out in bulk, because we have seen recently many laws and many laws have been amended and many laws have been repealed also. But there are still some obsolete laws existing from the colonial time, so that needs to be scraped out as well. So our Prime Minister Narendra Modi ji says one of his mission is to right India of maze of useless laws. So this strong decision by the central government to repeal such laws which are of no use will result into effective government and good governance. So there are many attempts still going on in identification and removal of such laws. So we hope India will be free of these archaic laws which are so burden to our country and the society in its functioning. So in hoping of good, I would like to conclude the video presentation. Thank you guys.